Good morning, everyone. This is Ming at CanAm. I would like to thank you for taking the time to listening in our webinar. Today, I'm excited to be joined by key thought leaders and legal experts in EB-5 to discuss and try to address some of the most asked questions about the EB-5 visa backlogs, processing time, and filing strategies. Since the passing of the EB-5 Reform and Integrity Act in 2022, there have already been more than 10,000 I-526E petitions filed under the new law, making the EB-5 program one of the most popular residency through investment programs globally. Many investors have successfully gained legal status in the U.S. and full access to the U.S. job market using the new EB-5 program's concurrent filing feature. We are very happy to see the program being working very well for our investor families. However, the program is not without new challenges. As the EB-5 landscape becomes increasingly complex, investors and industry stakeholders are navigating a critical moment. Visa demand is surging. Reserve categories are no longer safe from retrogression for China and Indian-born investors, and the clock is ticking on the program's 2026 grandfathering deadline. Today, we are bringing together a powerhouse panel for a data-driven, investor-focused discussion centered around the finding in CanAm's latest white paper, Visa Availability and Allocation as of July 2025. First, I would like to introduce our prestigious panelists who really all don't need my introduction. We have Mrs. Suzanne Lazicki, who is the author of the white paper, and more importantly, the person behind the famous Lucy Text blog, which is a must-read for all EB-5 practitioners as well as investors. We have Mr. Nikolai Henriksen, is a partner in Miller Mayer's immigration group. Nikolai has over a decade of experience representing both regional centers and investors, and I personally think he's the most well-traveled person I know in EB-5 with lots of good stories. We also have Mr. Joey Barnett with us today. He's a partner at WR Immigration. Joey currently serves on the American Immigration Lawyers Association's EB-5 committee and is a member of the IUSA editorial board. Many of you might also know him from his monthly visa bulletin chat with Mr. Charlie Oppenheim, which we'll listen to religiously. I will be moderating the panel today, and let's get started since we have a lot of content to go through. Hi, Suzanne. I think our conversation today have to start with the data analysis you did based on the latest AIIA FOIA data. Can you please share with us the key finding of the data and what we can learn from it?
One thing to know is that there are a lot of people in process to get an EB-5 visa. And when there are a lot of people in process and a limited number of visas, somebody's going to be waiting. So that's what we talk about when we talk about backlogs. So Min asked me to talk about the data that we have for EB-5 backlogs and how to interpret it. This is really a complicated issue, which is why usually I'm writing about it. And if you want to take the deep dive, you can look at what I've written up for CanAm, which addresses questions that investors commonly have about what's the backlog situation for EB-5. And today in this webinar, I just want to give a big picture. And first of all, I want to define what are we talking about when we talk about backlogs. What we're talking about is we're usually looking at the visa backlogs, which is what happens when you have more visa applicants in line than you have annual visas available. And that difference between number of people in the pipeline, number of visas available to give them, somebody's got to wait, those people who are waiting who are backlogged. So we're going to look at some numbers and then put the numbers in context. So if you go on to the next slide. So on this slide, this is a summary of the facts that we do have about the number of people in process. Looking on the right, first for post-RIA, this is people who've invested since 2022 and are mostly going for unreserved categories. The main thing that we know is the number of people who are starting the process and heading toward a visa. And the facts that we have are the number of I-526 and I-526E that have been filed. We have this information by country and TEA category up to January 2025, and then some more recent data about how those people are flowing through the process. For pre-RIA people with priority dates before 2022, we have information about where people are currently in the process waiting for a visa. The most important input that we have there is the National Visa Center waitlist, because a majority of the legacy backlog is people who are going through consular processing. So this is the facts that we have, and I want you to notice we do have solid information, number one. Number two, it is limited and it's not extremely current. So those are the constraints that we're looking at. And if you go on to the next slide, I want to talk about the EB-5 process, because it's really important to thinking about backlogs to know that there is a process that you have to go to that has multiple steps and multiple constraints. So when someone files I-526, they're not just going straight to being a visa applicant and being able to qualify for a visa. There are levels to go through. First of all, you go through I-526 processing. And even at that level, there are constraints. People don't just immediately get an I-526 approval. They have to wait until within the constraints of the staff available and the resources on I-526, you can finally get your I-526 looked at. So there are some pileups that happen at the I-526 stage, even before thinking about the visa limits. Once you have the I-526 approval, you go on to visa processing. And here it's a matter, there is, again, it's like a funnel. There are some processing constraints. You have to wait until you can go through the application steps, wait until a visa interview can be scheduled, or wait until the I-485 can go through. And then at the very base, you run up against the constraint that we're talking about in the process, which is a quota constraint. There's a numerical limit on the number of visas available. And so looking at this little process, a few things that I want to point out. One is that if you're up at the top, just starting the EB-5 process, and you want to know how long is it going to take me to get down to the bottom to get a visa, you want to look at all the people who are there below you. Because in theory, this is a first in, first out process overall. So you want to think how many people are down there waiting for I-526 processing, how many people with earlier priority dates are waiting for visas. I have to account for them to think it's how long it's going to take me to get down to the bottom. Another thing to recognize in this image is the issue of the visible versus invisible backlog. And we talk about that because the visa bulletin only looks at the number of people who are on that visa processing funnel. The visa bulletin looks at people at the visa stage. That's the visible backlog. But as far as you thinking about how many people are in front of you, you have to also think about the number of people waiting in I-526 processing. And so let's go on to the next slide and attach some numbers to the total number of people in process. And I call this a summary of the pipeline backlog, because what we're looking at here is not all people who are visa applicants right now. This is looking at not only people who are at the visa stage, but an estimate of the number of people who are at I-526 but will become visa applicants. And in this slide, I have multiple columns because EB-5 has multiple lanes. Some people are going for unreserved visas, some people are going for rural visas, some people for high unemployment. And again, well, I should mention too where these numbers come from. The unreserved estimate that I have there, this again is mainly off of the National Visa Center waitlist with some additional added in from the numbers that we have waiting for I-485 and still pending I-526. For rural and high unemployment, the set-aside categories, because what we know is the number of people who started the process, I took that data from January 2025 from AIIA about number of I-526 filings, multiplied by 2 and rounded down. So that's a way to get to an estimate of how many people who are starting the process, once they've added on their spouses and children, maybe some get denied, how many visas they're going to end up demanding. And this is an assumption. Some people think maybe we should multiply by more than that because family sizes can be bigger. But this just sort of gives a ballpark of how many people might be in line for the number of visas available. And because backlogs happen when there are more applicants in the pipeline than can get visas in a year, we want to look at the difference between that light blue line. How many applicants do we estimate are in the pipeline versus that dark blue line? How many visas are available in the category? And the reality is more complicated than that with country caps and some years with more visas available and everything. But this kind of gives us a baseline view of sort of what's the backlog situation. And just looking at overall, if you say, oh, there are around 60,000 people in line and around 10,000 visas available in a year, obviously somebody's going to be waiting. And if you look at the individual categories, you can see that for all the categories for which we have data, there is potentially a backlog situation in each category. Rural has more people in line significantly more people in line than can get visas in a typical year. High unemployment, unreserved, all of them are in a situation where there are more applicants than visas. So the question is not, is somebody going to be waiting and are they going to wait for a long time? That's certain. Somebody's going to be waiting and they're going to be waiting for a long time. The question is just who's going to be waiting and for how long. And that's where we start to drill down and especially look at the nuances. And the most important nuances that we look at is country-specific visa allocation and also the opportunity of potentially mixing and matching applicants across categories. If you go on to the next slide, I have another little picture to look at again instead of numbers. And my last analogy was funnels. On this slide, this is ships. If you can imagine, there are 4 ships in the harbor getting ready to take off, and each of them has a certain number of seats on it that are available. This picture is to scale. So each of those little squares represents 100. And you can see there's the unreserved category with about 6,800 seats, the rural category with around 2,000 seats, and so on. So every year when visas get allocated, they're filling up these seats on the ships with applicants that are there. And in this picture, you can see some of the seats are colored in orange. I colored in 7% of the seats orange. And this stands for the country caps in EB-5. Let's say you're from India. You have, let's say, reserved seats. You can at least count on Indians can get into 7% of the slot, EB-5 slots that are available. Maybe they can get into more. Maybe they can get into that gray area. The gray area are seats that are available on a priority basis to the rest of the world. But if the rest of the world, if there are not enough people to fill in the seats, then someone who is subject to the country cap on EB-5 visas potentially has opportunity to get more seats. So as far as how visas get allocated, when you've got too many applicants, not enough visas, who's going to get the visa? What Department of State looks at is they look at category. And in this image, I put a little passing lane symbol as an indicator that if someone is only approved for an unreserved visa, they can't skip over and take a rural visa instead, that there's no movement that direction. But if someone is approved for a rural visa, they also have the option to take an unreserved visa if one is available. So there can be movement from the reserved towards the unreserved category if necessary to optimize visa availability, which is nice to know because there are a lot more unreserved visas available than there are in the specific reserved categories. Priority date is another thing. Generally speaking, people with the older priority dates are going to get visas before those with the newer priority dates. In the unreserved category, we've got a lot of people with old priority dates who are waiting there. So anyone who's thinking about moving over to unreserved just needs to keep those old priority dates in mind. The country cap, we talked about China and India. If you're from China and India, you need to be thinking about how long could my wait time be? The worst case scenario is, what if only those 7% of slots are available to my country? That kind of defines what is the longest you could be waiting for a visa, is if you have to wait for just one of these shaded seats here, one of the only 7% of visas. But another thing to keep in mind is that the Department of State has to avoid unused visas. And we've seen this happening in unreserved every year, where they give 7% of visas to China, but then they don't have enough rest of the world applicants to take the rest of those visas. So they'll give more visas to China. So in reality, China's been getting thousands of unreserved visas a year instead of just the 500 or so that they could get under the country cap. And then another thing to think about that affects visa allocation is capacity, meaning the government's capacity to issue visas. So in real life, the rural and high unemployment boats have been sailing empty for the past 3 years because the government just hasn't had capacity to fill in. So that's another thing to keep in mind. If you go on to the next slide, I'm not going to talk about this in detail, but which I've done in things that I've written up, but I just want to say that when I'm thinking about how long is it going to take to allocate, or how can visas be allocated, what I'm doing is looking within each category and for each country at what is the difference between the number of people in line for this country and category and the number of visas available. And if I see, wow, there's a huge difference in the number of people in line and the visas available, minimum visas available, I think, is there any way to move around to optimize? For example, in high unemployment, I'm looking at the fact that there were 3,000, almost 4,000 rest of the world high unemployment applicants in line, and maybe only about 800 visas in a normal year available. That would mean high unemployment retrogression for rest of the world countries. Does that mean that if you're a high unemployment investor, you're going to be waiting over 4 years for a visa? And my answer to that is probably not, because I'm looking at the fact that a rest of the world high unemployment investor also has the option to request an unreserved rest of the world visa, and the differential there is much smaller. The number of rest of the world people in line, they could potentially all get visas in a year, and opening up space to move over to the unreserved category. On this page, I also look at just what is the biggest number in the supply category? Where are the most visas? And I'm seeing that biggest space, that biggest number of seats in unreserved rest of the world. That's a lot of visas available. It's not as many people in line for them. So who can skip over there potentially? Up until now, old applicants from China, they have been able to raid that pool of visas that are available on a priority basis to rest of the world. And increasingly in the reserved categories, as we see so many people in line, I think we'll see rural and high unemployment investors will want to think about, when I get my approval, maybe I want to request an unreserved visa because there is less of a crunch there. So many things I could say, but let's go on to the last slide, and I'll just quickly give my conclusions, and then you can read things I've written if you want to see the detail. But for me, the most important takeaway looking at the data is that there are backlogs. This is including in, I should say, rural and high unemployment. Both those categories, there are more people in line than there are visas available. So this is a fact to be aware of. And thanks to the influence of country caps, the wait time outlook is different if you're from China or India versus from rest of the world. If from China or India, retrogression coming up against a visa bulletin cutoff date, I would say, is inevitable at this point if you look at the number of people at both stages in the process, at I-526 and at visa. And that retrogression is going to be significant. So that's something to look at. For rest of the world, it is still possible, I think, to avoid retrogression if you're from rest of the world, thanks to the fact that people from reserved categories, if they get really crowded, can go over to unreserved, and unreserved does not look like it's long-term has enough applicants to retrogress. And then another thing to keep in mind is that things are just constantly changing. We looked at numbers as of January 2025. Those are changing day by day, as decreased by people who are getting visas, increased by people who are filing new I-526 every day. And then long-term, things can change. The law can change, either for better or for worse, to maybe provide visa relief or add new restrictions. So it's good to be aware of the dynamic situation. And I'm really looking forward to hearing what Joey and Nikolai have to say about the options there and how investors should interpret them.
Suzanne, thank you again for the high-level summary of what is causing the visa backlog, how bad it is really from the data that we have. And also more importantly, we are trying to have a more nuanced conversation in terms of what is options for Indian China-born investors and what are the alternative options that the rest of the world investor can consider when they are pursuing EB-5 for their families. Joey, you have probably represented hundreds of EB-5 investors since 2022, and as of now, we all know that we've been sounding alarms on the retrogression, but EB-5 is still, as of now, the most effective ways to help a lot of our investors to gain almost immediate legal status in the U.S. And I assume most of the filings that you guys are working on nowadays are concurrent filings. Could you please just share with us what exactly is concurrent filing, how does it work, and what is the benefit to our investors at the moment?
Sure. A concurrent EB-5 filing means that you file your EB-5 petition, the I-526, showing your lawfully obtained capital has been invested into a new commercial enterprise. And at the same time, you're able to file your green card adjustment application. That's the Form I-485. And with that Form I-85, you're able to file for work and travel authorization as interim benefits during the time in which the adjustment remains pending. You're only able to do that if a visa is available based on your country of chargeability and the category that you're in. And since the enactment of the law in 2022, the rural, high unemployment area, and infrastructure reserve categories or set-aside categories have been current, meaning people from anywhere in the world who are lawfully in the United States can file an adjustment at the same time that they file the EB-5 petition. Beforehand, EB-5 investors needed to wait for their I-526 to be approved in order to file the adjustment. So by able to file the adjustment at the same time, they are able to get these interim benefits and have a backup option in the event something were to happen with their non-immigrant visa status. Min, you mentioned all the people who are in the United States right now. Most of EB-5 investors since 2022 are located in the United States, not outside of the United States. They're here on short-term work visas or student visas. They don't see other options available for them, and they're turning to EB-5 because it's really one of the few options that are available to file the adjustment at this time. And we have a number of Indian and Chinese investors who are stuck in H1 or who are in H1B status, stuck in EB2, EB3 backlogs, or on F1, aren't able to find an H1B sponsor after OPT or something like that, and they are turning to EB-5. So there is a huge, huge benefit of doing the concurrent adjustment of status. And again, you can only do that if a visa is available. And based on what Suzanne was saying is that at some point, most likely in 2026, visas will not be available for most EB-5 applicants, particularly for the high unemployment areas and likely for the rural areas as well. And Suzanne's white paper that you guys all have downloaded is a really, really great resource. It explains it in plain English, all of the different options that different investors have to make sure that they can get the green card as fast as possible. And it's really important that you work with your immigration attorney and make sure that you are acting as quickly as possible to get your case filed and to make sure that everything goes as smoothly as you can. You don't want anything stopping USCIS from taking action on your case. If there are delays there, that means you're going to be further in the waiting for the backlog. One thing I say to all my EB-5 investors who are in the United States is a visa is available today that allows you to file your adjustment of status. But the visa bulletin must be current for your priority date at the time that the I-526E is approved in order for USCIS to adjudicate the adjustment. If there is a final action date that is before your priority date, then you are in that backlog. You're in the United States. You are in a period of authorized stay. You're not accruing unlawful presence, but you also don't have the conditional green card yet. We have to wait for the visa bulletin to advance for your priority date to become current, and then they can adjudicate your adjustment of status. So this concurrent option is a great short-term benefit. Ultimately, though, your green card and your family's green card is based on the visa queue that Suzanne mentioned, and there will be some wait time, particularly for Chinese and for Indian nationals. You know, one of the reasons why we are pushing so much information on this right now is because 10 years ago, this happened before, and not everybody understood it. And there were a number of Chinese investors in the unreserved category who made their $500,000 investment, who still haven't gotten their conditional green card because of the per country caps and the visa backlogs. So they invested 10 years ago, they still don't have their conditional green card. People are doing this EB-5 not for the investment, they're doing it for the green card. And so you need to understand why this timing matters. Your green card, I don't want to say is going to be delayed, but there is some time for it in order to get ripe. And in the meantime, you need to make sure that you are either maintaining your lawful status or making sure that you're kind of staying off the radar, because even though you're in a pending adjustment of status, that actually is not lawful immigration status. USCIS is very, very clear about this. You're not accruing unlawful presence, but you're not in lawful immigration status either. And so we advise our clients to maintain their non-immigrant visa status as long as possible. Easier said than done, in particular when there are extended visa backlogs. But that is the safest option. It gives you the most amount of protection, and it gives you the most amount of options for US immigration moving forward. One thing that CanAm asked me to speak about was this 2026 grandfathering deadline. And I want to explain what that is because it's something that a lot of investors are asking about right now. So under the EB-5 Reform Act, an investor who files their I-526 by September 30th, 2026 is grandfathered. That means that even if the regional center program is not reauthorized after September of 2027, those filings still get adjudicated under the current law, and you're still able to get the immigration benefit from your investment. So that's very important, and why I think a lot of people in EB-5 are expecting to see a lot of activity in the next 12 months. And then come October of 2026, there will likely be a fall off. The question of how does this relate to the EB-5 backlog? They're next to each other. I don't know if they're really impacting each other. Grandfathering doesn't give you priority in the visa queue. You must still wait for visa availability, which depends on your priority date, your country of birth. And so There are visas that are still allocated to the EB-5 category because there still is the direct or standalone visas program. And so there are visas to pull from. And so eventually you will get that immigration benefit, even if Congress does not extend the program in 2027. My personal take is they will extend it, just like they have extended it, I don't know, dozens and dozens of times before, because it's a great economic tool for the United States. And, a lot of congressmen and senators have money that is brought into their districts through EB-5. And so they've seen the benefit for it, the jobs that are created in their jurisdiction. So I wanted just to touch on that 2026 grandfather deadline. I'll also say that, and I agree with Suzanne, that this is something that is constantly changing, which is why immigration attorneys are always looking at the visa bulletin every month it comes out. And we're always looking at it to see, has it moved forward? Has it retrogressed? Because it impacts a lot of our clients' lives. And so we do a monthly call on YouTube with the guy who used to write the visa bulletin. His name's Charlie Oppenheim. He's now works for WR Immigration, and he has got great insight. He understands this better than most. And so we invite you to take a look at our videos online about that as well. But really, the Concurrent is huge because it allows you to remain in the United States while the time that your EB-5 case is pending, and even throughout the backlog. And that's what's, I think, driving people towards EB-5 at this time.
I do wanted to build on this and just asking one more question on the latest visa bulletin that we've seen. I think the latest data has shown that as end of this month, there's still only a very small number of actual EB-5 visa been issued this year, despite the huge pending numbers of petitions that have been waiting to is already approved, that pending interview at the consular or waiting to be adjudicated on their 485. Does this mean that we probably are not going to see the actual retrogression on the visa bulletin later next year?
I think we will see it in 2026. As Suzanne mentioned, we need USCIS to adjudicate more I-526s, because only when those are approved will the Department of State see the demand for the visa numbers. And only when that demand exceeds the supply will they impose a final action date. So as USCIS adjudicates more, that demand goes up, and we will see a final action date in 2026, which is why I'm telling people that if you're looking to do EB-5, now is the time. Get your spot in line. You get your spot in line by filing the I-526. The other thing I want to say, because this gets asked me a lot, is you cannot port your prior EB-2, EB-3, you cannot port those EB-2, EB-3 priority dates to EB-5. They're mutually exclusive. And so for people in the United States who are waiting in those backlogs, that does not benefit you for EB-5 purposes.
Thank you, Joey. That's very helpful. I think, we talked about the visa backlog. We talked about how concurrent filing can still be a very useful tool for a lot of our investors. The last part of the webinar, I really wanted to discuss a little bit more in depth with Nikolai. In your actual practice, we know that question we've been asked every day by new EB-5 investors who are looking at EB-5. Should I choose a rural project or should I choose a high-employed project? I think to give an answer to that is become harder and harder, especially if the investor is born in India and China. So what is your approach to this very complicated questions at this point?
Yeah, that really is the thing that you discuss first with any investor who's reaching out and is interested in EB-5. And the way I approach it really depends on the level of expertise and knowledge of the investor. How much do they already know? And I think anybody listening to this webinar, kudos to you for taking the step in the right direction and educating yourself about this very complicated issue, because I think that's absolutely critical. This is not easy stuff. It's not easy for attorneys like me. I've been practicing in EB-5 for 20 years. The stuff is complicated. And even if you understand it, the variance and the disparity in the dates and the consequence of a waiting line, how long will it be? You know, you can read Suzanne's paper, which again, I encourage everyone to do. It is written in plain English, but it also does say in plain English, these dates can vary widely, huge variance. So how do you make that an actionable data point? And that's really difficult, and difficult to explain to a potential investor. So I would think the first thing is for investors to educate themselves and try to understand as much as possible what it is we're talking about and how it works. The second step is to align yourself with, I think, an immigration attorney like Joey or like me, or somebody who has expertise in the field that can help you make a decision based on various factors. And what are those factors? Well, you really need to analyze the facts and circumstances specific to the investor and their family. What are their immigration goals? What is their timing? What are their timing needs? Are there kids that perhaps are already in the US in F status? Is there a possibility of cross-chargeability, right? Sometimes people forget that if you have a spouse that's not born in India or China, you know, let's say a Chinese individual is married to somebody from the Philippines, well, you can become chargeable to the Philippines. And then that changes the calculus with respect to whether you want to choose a high unemployment project or a rural project. It's very individual. I mean, I have long conversations with families about what it is that they want to do. I think the assumption in this conversation has been so far, everybody wants to get to the US as quickly as possible. Actually, that's not always true. There are many families that don't want to move right away. You know, I have many clients who end up getting visas and they come to the US and then they get reentry permits and they go back home and are out for significant periods of time. And we have to talk to them about how to manage abandonment of residency and so forth. But, you know, a family where an individual has business interests and maybe they have young kids, they're very young kids that are still going to school, maybe the waiting for them is not as detrimental as it might be for another family. But so once you have a full understanding of the facts and circumstances of the family, then I think the big demarcation line is, are you in the US or are you not in the US, right? I mean, that's what we've been talking about. The advantages, the analysis differs for somebody who's in the US and who can file concurrently versus somebody who can't, right? So if you're in the US and the categories are current, you know, there's an argument that if you think high unemployment is going to have a longer waiting line, well, so what? I like the project. I feel really comfortable with this project for whatever reason. I recognize that I may be waiting longer, but as Joey just explained, the interim benefits of work and travel authorization give me what I want, and I'm happy to wait until I get approval in the high unemployment category and eventually get my green card. I don't mind waiting. But not everybody's going to have that approach, right? I mean, there's a psychological benefit, I think, that people sometimes underestimate to actually having the I-526 be approved, as it certainly will be in a rural category, right? So the rural advantages are there, priority processing and more visas. So that even if you are concurrently filing, getting that approval in hand and potentially making that actionable before high unemployment may be advantageous for you. So, you know, at the end of the day, all of the same concerns apply, whether there's retrogression or not. A person has to make a decision, right? So they need to assess, understand what is the issue, what are my facts and circumstances, and then they have to make a decision. And then the usual sorts of analyses come into play. in terms of picking service advisors that have expertise and knowledge in the issues that face them, regional centers that have track records of putting out good projects that are going to satisfy the immigration and the investment goals of investors. So that's how I generally counsel. I agree with you, Min, that the consultations on this issue have gotten much longer. It's really hard to get this in an hour-long conversation, frankly, which is typically how long my consultations are. It takes a lot of explaining, and depending on how much information and knowledge a person has before they come to that consultation will bear on how long it takes to explain these complicated issues to them.
I totally agree with you, but I do have to say that in the past couple of years, our investors have become a lot more knowledgeable regarding the visa backlog, the allocation issues, and they do appreciate that the industry has become a lot more transparent, and these data has become a lot more available for investors to make a more well-informed decision at the time of the filing. Like Nikolai, I 100% agree with you that this has become a very personalized process, right? Each investor have different personal circumstances. Some might prefer a high unemployment project because the financial feasibility of the project is very attractive to certain investor, while some investor might be still more focusing on the rural priority processing. And I think it's very important for us, the regional center, as well as the attorneys to help them fully understand the process. I do have a question for both Joey and Nikolai. As we all know that, as Suzanne explained, we now have these ships of visa, different visa categories that can be interchangeable for investors. But in practice, now we're 3 years into the new program. Have you gotten an investor who applied under the rural category, got their petition approved, and at the time of actually select which category of the visa that they're about to use, they're willing to switch categories? And how does that process work in practice?
So switching categories is possible, not at the I-526 stage, but at the NVC stage. NVC gives you the option of choosing, and you can look on your receipt notice or your approval notice, your I-526. The approval notice will indicate if you're eligible for multiple categories. And at that point in time, you can let NVC know which category you might choose. Unfortunately, and this is really unfortunate because as Joey and others have indicated, the majority of petitions are actually adjustment petitions. USCIS has yet to come out with a mechanism for switching. We've tried to do it on the cover letter, and it's not. There isn't a process that is foolproof. And I think the ALA EB-5 committee has raised this issue with USCIS, but as far as I know, they have yet to meaningfully comment on it or issue any kind of guidance that's helpful on how to do it.
That's correct. And when USCIS is adjudicating the adjustments for reserve set-asides, they just approve it. They issue the conditional green card, and on it, it says rural or high unemployment. There's no option to choose to go into the unreserved category. And it's been current since and a lot of people are not willing to take that risk to switch the category. At least I've seen that for some folks like in Vietnam who have approved I-526s who are doing consular processing. Like they still want to do the reserve visas, even if it is current in the unreserved as well. I've had some conversations with that, and we've just decided to do what's best for what the client wants. I will say one thing that I find sort of fascinating is USCIS is prioritizing the processing of 526Es in the rural category. I think we've seen something like 3 times as many rural approvals as high unemployment approvals at this point. Well, that means that the Department of State is going to see likely more demand for those visas in the rural category than in the high unemployment category, even if the supply for rural is twice as much as high unemployment. If they're approving 3, 4, 5 times the number of 526s, it's possible that we see a final action date for rural before we see it for high unemployment, just because of kind of the flow that Suzanne was showing us before.
I absolutely agree that I think we will see, investor really needing this flexibility of category change later in the process as we're approaching the grandfathering deadline of 2026. As we move on to the last part of the webinar, I think these are really some of the burning questions that we've been talking about inside the industry, and the investors also, wanting clarities from us. I don't think we will all have answer to these questions, but I would also love to hear your opinions on that. Nikolai, how many EB-5 deadline we have been through in the last 10 years, with market seem to be, really going crazy whenever we have one of the deadlines. So do you think what you witnessed in different markets for EB-5 is the potential risk of retrogression motivating more investor to file at the moment, or we're seeing more of a cool down of the market demand at the moment?
Yeah, they keep it stressful. I always joke that the gray in my beard is certainly thanks to all of USCIS's deadlines. So it's been a challenge to go through them all. Whether retrogression is a deterrent or a motivator, I think it's both. And I would go back to what I said earlier about the facts and circumstances specific to a family, right? I mean, there are certainly families that have a family makeup where it just may not make sense for them. They're just not able to take on that risk. Maybe financially, they're not able to, put away $800,000 for a hold period like that, and maybe EB-5 is not for them. But I think for the most part, it's a motivator. Generally, I think once people understand the benefit of EB-5, what it can do, particularly if they're concurrently filing in the U.S., and the visa categories and the set-aside categories are still current, that's a tangible immigration benefit that they can seize immediately. They're graduating from college, their STEM OPT is about to run out, or whatever their circumstances, and EB-5 is really a lifeline for them that is actionable very, very relatively quickly in the context of processing times in immigration generally, right? You can live and work in the U.S. If you file the adjustment. So to that extent, it's a motivator, I think. I've never had a client tell me they wish they would have waited longer to file EB-5 ever. So I think that to Joey's point, like you need to file now. And look, it's difficult. It's a lot of money. What we're talking about here is complicated, and we haven't even talked about project selection and understanding how EB-5 works, and all of that is in and of itself complicated. No one should think that this is an easy process without requiring some real input and application from the investor. But I would advise people, if they do decide to do EB-5, of course, do your diligence, of course, try to understand the issues, but act expeditiously, because I have seen many, many kids, for example, age out by a day. Time matters, actually. And that may seem quite abstract at this point in time when you're talking about something that's going to happen so far in the future. But when you get that email from NVC saying, I'm sorry, your kid aged out by a day, that's a tough message to bring back to the parents. So,
absolutely, Suzanne, I'm gonna give this really kind of tough question to you. We all been reading your blogs for years now. I think you played a huge role in educate, the market, the investors about visa backlogs. And yes, we have seen investor knowledge improved significantly over the years. Do you think through the effort that industry has been making, getting more data available to our investors and educate, I know looking at the backlog data is still very a chilling situation, but do you think EB-5 can be a viable long-term option for our global investor communities?
Well, I think at least it will be a reliable option. What we don't want to see is people thinking, I'm going to invest and get a green card, and then have no idea when they're actually going to get the green card. And if they realize, oh, this could take me 8 years to get a green card, and they're fine with it, then that's okay. If they invest thinking, I'm going to be able to get a green card in 3 years, and then it's actually 8 years, that can be a personal disaster. So we want people to have a sense of what they're getting into and be able to make informed decisions.
Yeah, I think that's very important is through the consultation, how we going to make sure that investors' expectations and the actual reality of the visa availability can be aligned. Joey, I'm sure now the question you're getting asked is how long is the I-526E petitions will take to be processed, and how long is the wait time takes? Can you give me maybe a 30 seconds kind of
Sure.
response to this very
Yeah, can I just say one thing? Because I wanted to mention about it being a motivator. I think retrogression is a huge motivator right now. You can't file the adjustment if there isn't a visa available. People are using EB-5 and this concurrent adjustment as a backup plan. What happens if your H-1B employer lays you off and you can't find a transfer? On day 61, you have to leave. Well, if you have a EB-5 a concurrent adjustment filed by then, you don't have to, right? It's a backup plan. You use the EAD as a backup in case something were to happen. Of course, if a great opportunity comes or you want to start your own business and you got a great idea, okay, great, go use your EAD. But I think having that as a backup plan and allowing you to remain in the United States without accruing unlawful presence is a huge, huge motivator for people. The other thing that I want to say is there's lots of WeChats, WhatsApps, Reddits out there. Oh yeah, I got my green card in 8 months. That is not reality for somebody who is filing today. The people who are getting their green cards or conditional green cards today, it is current. They didn't have a backlog. That is not the case for folks who are filing I-526s today. So what you read about what has happened in the past is not what is going to be happening in the future. And I think that is part of, the expectations that investors have that need to kind of be reset. That's a part of the informed decision making. There are risks in everything in life. The key is mitigating those risks, understanding the risks, and making sure, as Suzanne mentioned, you making an informed decision. When I'm talking to EB-5 investors, I'm not looking at worst case scenario because I don't think it's going to happen. I say to my clients who are born in India that it can take maybe around 3 to 5 years or so before a visa is available. And that has to do mostly with the fact that I am optimistic that the unreserved India will clear out and there will be more visas available for the dual approval categories for rural and high unemployment. For China, I'm expecting it to be longer. There's significantly more demand from China than there is from India, and it's arguably the same amount of visas other than priority dates. So, I think people really do need to understand this is a long-term process. You need to work with an immigration attorney who's going to be with you throughout, and they need to work with a regional center that's going to be supporting you throughout this, because the way that it works is you can't file your I-829 showing that the jobs were created, that the money was sustained until after you get the conditional green card, which is after the visa backlog. So you better make sure that the regional center and the developer are going to be supporting you throughout that process. That is key. And so that's something that I think is very important for people to understand. You got to have a very institutional regional center operator that is helping you along the way. That's invaluable.
Joey, I know you touched upon, during your session of the discussion that how the grandfathering in 2026 might intersect with the visa backlog that we all expect to happen sometime in 2026. To conclude the webinar, Nikolai, can I just also get your take on this? If the backlog, the visa bulletin backlog do occur before the grandfathering deadline, do you still suggest investor to file before the grandfathering deadline, or the deadline maybe at that point will not mean much to our investors?
I would generally say that also. I mean, this is sort of my fallback now. I've said it 3 times, but it depends on the circumstances of the family and what it is they're looking for and what it is they're trying to achieve. But if they are interested in EB-5, I think filing before the deadline obviously is critical, because as Joey explained, what the deadline means is that if you file after the deadline, there's no guarantee that the U.S. Government will process your EB-5 application and that you'll derive the benefit that you're applying for. So if you want to give it a try, certainly filing before the grandfathering deadline in September 2026 is what I would advise.
Thank you, everybody, so much for joining the webinar today. I'm glad that we have the opportunity to have this very nuanced conversations on the visa backlog at the moment. As you all know, there's a lot of discussions and noises, on the market at the moment. And I think it's very important for the industry experts like you guys to come together to provide these transparency, these knowledge, these experience that we had over the past decade in EB-5 to give investors clear guidance along the way. Suzanne, I wanted to thank you again for working with us on the white paper. I really read it word by word. I think a lot of our investors will find the white paper super, super helpful at this time in their family's decision if EB-5 is a suitable option for them and in what category. Please, we have published the white paper on our website now. You can go on our website to download it. And thank you all for joining us today.